The wonderful world of civil procedure, of course, features many great topics, and we, in this module, are going to talk about personal jurisdiction. And we're going to use that phrase a lot, so let's not write it out all the time. Let's abbreviate it PJ. We're into abbreves around here, so PJ works just fine. Some courses call this adjudicatory jurisdiction, some call it territorial jurisdiction. We'll just call it personal jurisdiction, or that Pennoyer stuff. Any name like that will do. Now, this can be difficult material, and most courses spend a lot of time on it. But we're going to cut it down to size because it's only about one thing. There's only one question in all of personal jurisdiction, and that is, can the plaintiff sue the defendant in this state? That's it. That's all we're asking. Can the plaintiff sue the defendant in this state? And folks, that question is going to be answered exactly the same way, whether we're in state court in that state or federal court in that state. So in any case at all, whether you go to federal court or state court, the analysis is exactly the same. And the analysis means this, that in any case, the court, whether it's federal or state, simply does not matter, the court must have power over something. And there are two things the court may have power over to give it personal jurisdiction. One is that it may have power over the defendant himself. And the other is it may have power over the defendant's property. Now, let's talk some vocabulary here. There are three kinds of personal jurisdiction. There is in personam, there is in rem, and there is quasi in rem. Now, what's the difference? Here it is. The key is this. Within personam, the court has power over the defendant himself. And it's because the defendant has done something there or has some connection with that forum. Maybe the defendant was served with process there. Maybe the defendant sent a product in there. Maybe the defendant caused an effect there. But we have power over the defendant himself because he has some connection with that state. With in rem and quasi in rem jurisdiction, the court does not have power over the defendant himself, but the defendant has property in the forum, in the state, and the court has power over that property, not over the defendant, but over the defendant's property. Now, you always prefer in personam jurisdiction, but sometimes you cannot get it. And if you cannot get it, maybe you can use in rem or quasi in rem jurisdiction. Because maybe, even though you have no power over the defendant's person, maybe the defendant did leave some property in the forum, and we can exercise jurisdiction over that property, and that would be in rem or quasi in rem jurisdiction. Now, how do we know whether a court has this kind of power? Well, it is all set by due process. The due process clauses of the Constitution require that we have personal jurisdiction over the defendant. Personal jurisdiction over the plaintiff is never a problem. It's automatic because the plaintiff filed suit in this forum and therefore consented to jurisdiction. So the question is whether we have personal jurisdiction over the defendant or the defendant's property. And due process sets the outer boundary of how far a court can go in exercising that power. Think of it as a big circle, the due process circle. And if our case is inside the due process circle, that means that our judgment is going to be constitutionally valid, and it will therefore be entitled to full faith and credit in other states. But if our case falls outside that due process circle, then the judgment entered by the court will be void, and it is not entitled to full faith and credit. It cannot be enforced anywhere, not even in the state where it was entered. So we have to have a case that is inside that due process circle for it to be constitutionally valid. And we're going to spend a lot of time figuring out what that due process circle looks like. how wide it is. Now, here is where it gets interesting, though. The fact that our case falls within the due process circle does not mean that the court has personal jurisdiction. There is another step. And the step is this: the state where we sue, the state must have a statute that allows for personal jurisdiction. You see, the states do not have to take all the power that the Due Process Clause would give it. The states are free to pick and choose, and they do not have to use all of that authority. And personal jurisdiction authority is not self-executing. The fact that something would be constitutional for a state court to do, to enter a judgment, does not give the state court that power. It has to have the power from a statute. So that means that analytically on the exam, the first step is going to be statutory. You are going to ask whether there is a state statute in the state where we sue that allows jurisdiction in this case. If there is, then we go to the second question, and that is, would jurisdiction be constitutional? Does the case fit within the due process circle? Now, having said that on the exam, the first step will be statutory and the second step will be constitutional, in our time together, we're going to go in reverse order. We're going to talk first about the constitutional limits on personal jurisdiction, and then we'll talk about the statute. We do it this way because most courses spend much more time on the constitutional analysis than the statutory. Plus, let me promise you, once we understand the constitutional analysis, the statutory analysis is usually very, very easy. So we are in a very big module, personal jurisdiction. Let's subdivide. Section A is about in personam jurisdiction. And as you know, with in personam jurisdiction, the court has power over the defendant himself, not over the defendant's property. And here we get some more vocabulary. In personam jurisdiction will always be either general or specific. With general in personam jurisdiction, the defendant can be sued in this state on a claim that arose anywhere in the world. If California has general in personam jurisdiction over you, you can be sued on a claim that arose from your activities in California, or you can be sued on a claim that arose from your activities in New York, or you can be sued in California on a claim that arose from your activities in Kuala Lumpur. General jurisdiction. You can be sued in that state on a claim that arose anywhere in the world. But with specific jurisdiction, it's different. Specific jurisdiction, the defendant is being sued on a claim that arises in the forum. So if California had specific in personam jurisdiction over you, you are being sued in California for a claim arising from something you did in California. And this idea of whether the claim arises from something the defendant did in the forum is the idea of relatedness. And we will talk about that throughout the materials. And the whole idea of general and specific will come up throughout the materials. Now, again, we are in the module on personal jurisdiction. We're in section A about in personam jurisdiction. Now, subsection 1 is the constitutional limit. Let's define the due process circle. And friends, to do this, we are going to walk through a whole series of Supreme Court cases, starting with Pennoyer in 1878, all the way up to the present time. Now, why do we do this? Folks, the law today is an amalgam of all these cases that have gone on for well over a century. Now, it is crucial that you, on the exam, not write a history essay. That's not your job. Instead, the reason we go through all these cases is that we have to learn from each case the relevant principles that will apply when we do a personal jurisdiction hypothetical today. So in each case, we're looking for principles, for rules, for guidance that will be good for us today. At the end, when we get through this tour of all the cases, I am going to pull them all together in one analytical framework that I think will work on any personal jurisdiction hypo. The first case is Pennoyer. Everybody has it in the case book, 1878. Pennoyer gives us what are still to this day known as the traditional bases of in personam jurisdiction. The traditional bases are these. One is that the defendant is served with process in the forum. The defendant is served with process in the forum. Now, we usually refer to this as presence as a basis of jurisdiction, and that's fine, except it doesn't mean that you were present anytime. You had to be present when you were served with process. And that, under Pennoyer, gives the state general jurisdiction. Service of process on the defendant in the forum gives general jurisdiction. That is a traditional basis. A second traditional basis is that the defendant's agent is served with process in the forum. Pretty much anything you can do through an agent. So if you have an agent in the state, the agent may be served with process, and that may be counted for jurisdiction over you. The third traditional basis is the defendant is domiciled in the forum. And if the defendant's domiciled in the forum, that also gives the court general jurisdiction. You can be sued there on a claim that arose anywhere in the world. Now, Pennoyer did not use the word domicile. It used the words resides and residence, but it meant domicile, and that has always been a basis of general jurisdiction. And then fourth, the defendant consents to jurisdiction. Of course, you can consent to jurisdiction. So 4 traditional bases: service of process on the defendant in the forum, or service of process on the defendant's agent in the forum, or defendant is domiciled in the forum, or defendant consents. Now notice, under this regime, it's pretty tough to get in personam, because if the defendant's not domiciled here, does not consent here, does not have an agent, the only way you can sue him here is to serve process on him in the forum. And this became too rigid, too limiting as society became more mobile, because it became easy for somebody to go into a state, commit a tort, get out of the state before we could serve process on him. What could we do? The court reacted by expanding the traditional bases of Pennoyer. And the best example of that expansion is Hess versus Pulaski. Hess versus Pulaski, Supreme Court, 1927, Pennsylvanian, drives in his own automobile up to Massachusetts, and while in Massachusetts is involved in a car wreck, injuring the plaintiff, who was a Massachusetts citizen. The Massachusetts plaintiff wants to sue the Pennsylvania defendant in Massachusetts, but the Pennsylvanian had gone back home, so you can't serve process on him in the forum. It looks like the plaintiff's out of luck under Pennoyer, but no. The Supreme Court upholds jurisdiction under the Non-Resident Motorist Act. The Non-Resident Motorist Act is now present in every state to this day. Every single state in the Union has this. And it is a statute that says by driving in our state, you have consented to jurisdiction for a case arising from the operation of that motor vehicle. And not only that, but you appoint an agent for service of process. It happens to be a state officer, the registrar of motor vehicles. So notice what this does. It's brilliant. It expands Pennoyer from consent to implied consent. When you drive across that line, you're not actually consenting, but we will infer that you have consented because you came in a motor vehicle. We infer that you have consented to jurisdiction for any wreck arising from your operation of the motor vehicle, and you have appointed an agent for service of process. Notice that these statutes give specific jurisdiction. So the claim against that Pennsylvanian must arise from his operation of the motor vehicle. It must arise from something he did in the forum. Folks, that was true in 1927, and it is true today. Every single time you drive across a state line, you are consenting to specific jurisdiction over you for a claim arising from your operation of the motor vehicle, and you are appointing a state officer as your agent for service of process. So for decades, the court expanded the pensioner bases. Then comes 1945 and international shoe. Now the court is not expanding the traditional bases as Hess did, but it comes up with a new formula. The time had come to restate principles, and the court does that in international shoe. Now, you know the phrase. There's a famous phrase from this case, and everybody has it circled in the case book, and it is this. It says that there's jurisdiction if the defendant has such minimum contacts with the forum so that jurisdiction does not offend traditional notions of fair play and substantial justice. Defendant has such minimum contacts with the forum so that jurisdiction does not offend traditional notions of fair play and substantial justice. Remember that phrase? Absolutely. Absolutely, we've got that phrase. Now, what do we notice about that phrase? That phrase is absolute baloney. There's not a single phrase within that big phrase that anyone can define. What are minimum contacts? What's fair play? What's substantial justice? It's absolutely open-ended, amorphous stuff. And here we are, more than 7 decades later, we are still trying to figure out what the international shoe test means. I do think we can note a couple of things, though. Notice that by now, by 1945, when shoe was decided, you can serve process outside the forum. By 1945, it is clear that we can serve process on a defendant even though the defendant's not inside the forum where we are suing him. Just so the defendant has such minimum contacts with the forum so that exercise of jurisdiction does not offend traditional notions, fair play, substantial justice. Another thing to note, international shoe, that test seems to have 2 parts to it. There seems to be a contact part and there seems to be a fairness part. And we will confirm that in later Supreme Court cases. And then notice something else about international shoe. Nowhere does the court say that it is overruling Pennoyer. In fact, quite the opposite. When you go back and find that magic phrase about minimum contacts, look at the phrase right before it. The court says minimum contacts is the test if the defendant is not present in the forum. And that at least implies pretty strongly that the traditional bases are still good, that international shoe is an alternative to go alongside the traditional bases, because presence is still good. If you can't get that, then try international shoe.